A couple of days ago, I started talking about this situation with Blake Lively and Justin Baldoni. Now, when I first put out my two videos, because I've actually done two videos on it, I admitted that I didn't really know who Blake Lively was. And I did go and I watched the movie and I've been reading up. And one of the things that I got wrong, I thought what she put through originally that was reported on the New York Times article, I thought it was a lawsuit, but it wasn't a lawsuit. It was some kind of just a complaint that was filed. But what Justin Baldoni has done, he's actually filed a lawsuit. He filed a lawsuit against the New York Times regarding the whole Blake Lively story, saying that they basically cherry picked situations to make him look bad and that she didn't file a lawsuit because she didn't want to sit for a deposition. Now, this article from Variety is a long article, and since I did the New York Times long article, I'm going to do this whole article as well from Tatiana Siegel. So this is a long article, so buckle up. All right, it says, on June 2nd, 2023, Blake Lively began a text exchange with her It Ends With Us director and co-star Justin Baldoni that blamed her assistant for not getting her an updated batch of script pages. She didn't realize they were new, Lively wrote. New pages can always be sent to me as well, please. The actress signed the missive with an X, the universal symbol for a kiss. Lively followed up with another text shortly thereafter. I'm just pumping in my trailer if you want to work out our lines. Baldoni responded, copy, eating with the crew and we'll head that way. 18 months later, that interaction was depicted in a New York Times bombshell report in a far more sinister light. The Times wrote, Baldoni repeatedly entered her makeup trailer uninvited while she was undressed, including when she was breastfeeding. That discrepancy is one of many highlighted in a scathing $250 million lawsuit filed Tuesday afternoon by Baldoni against the Times in LA Superior Court. Baldoni is among a group of 10 plaintiffs that includes publicists Melissa Nathan and Jennifer Abel, who are suing the newspaper for libel and false light invasion of privacy over the December 21st article titled, We Can Bury Anyone, Inside a Hollywood Smear Machine. The parties, which also include It Ends With Us producers Jamie Heath and Steve Sarowitz, claimed that the Times relied on cherry-picked and altered communication stripped of necessary context and deliberately spliced to mislead. A New York Times spokesperson responded, the role of an independent news organization is to follow the facts where they lead. Our story was meticulously and responsibly reported. It was based on a review of thousands of pages of original documents, including the text messages and emails that we quote accurately and at length in the article. To date, Wayfarer Studios, Mr. Baldoni, the other subjects of the article, and their representatives have not pointed to a single error. We published their full statement in response to the allegations in the article as well. We plan to vigorously defend against the lawsuit. The 87-page complaint, which also accuses the Times of promissory fraud and breach of implied-in-fact contract, offers a rebuttal of the narratives set forth in the 4,000-word article that has rocked Hollywood and led to WME dropping Baldoni as a client hours after publication. Written by Megan Twohey, Mike McIntyre, and Julie Tate, the piece painted Lively as an actress who allegedly endured months of sexual harassment from Baldoni and Heath and supposedly faced retaliation in the form of a smear campaign because she voiced her concerns. But according to the lawsuit, it was Lively who embarked on a strategic and manipulative smear campaign of her own and used false sexual harassment allegations to assert unilateral control over every aspect of the production. And according to the suit, Lively's husband, actor Ryan Reynolds, allegedly berated Baldoni in an aggressive manner during a heated meeting at their Tribeca penthouse in New York, accusing him of fat shaming his wife. The suit claims that the A-list actor also pressured Baldoni's agency, WME, to drop the director during the Deadpool and Wolverine premiere in July, well before Baldoni enlisted crisis PR. A WME rep denies that there was any pressure from Reynolds or Lively to drop Baldoni as a client and says his former agent wasn't at that premiere. Attorney Brian Friedman, who filed the lawsuit on behalf of the plaintiffs, tells Variety that the Times cowered to the wants and whims of two powerful, untouchable Hollywood elites, disregarding journalistic practices and ethics once befitting of the revered publication by using doctored and manipulated text and intentionally omitting texts which dispute their chosen PR narrative. The Times reporting that Nathan and Abel planted negative stories about Lively with the press was bolstered by one particular text exchange in which the two appeared to take a victory lap following a Daily Mail story about Lively that slammed her tone-deaf promotion of the film about DV and resurfacing embarrassing interviews from her past. "You really outdid yourself with this piece," Abel wrote, prompting Nathan to reply, "That's why you hired me, right? I'm the best." But in its full context, it appears as though Nathan and Abel are jokingly taking credit for a story that emerged organically. The story omits a Nathan text that preceded the exchange in which she says she was uninvolved in the story's publication. "Damn, this is unfair. It's also not me," she wrote. The Times also clipped Abel's use of the upside down smiley face emoji, which is typically used to convey sarcasm. The Times story relied almost entirely on Lively's unverified and self-serving narrative, lifting it nearly verbatim while disregarding an abundance of evidence that contradicted her claims and exposed her true motives, the suit said. Lively's side of the story was laid out in an 80-page letter filed December 20th with the California Civil Rights Department, which the Times used as its bedrock for its story. Unlike a lawsuit, CRD, which is the Civil Rights Department, complaints typically remain confidential unless they are leaked. In its previous reporting on the subject, Variety was unable to confirm that Lively even filed a letter with the department declining to comment on the case. So that is the difference right here. What I thought was a lawsuit was a complaint. A complaint is not a lawsuit, but what Baldoni filed was a lawsuit. Notably, Lively chose not to file a lawsuit against Baldoni, Wayfarer, or any of the plaintiffs, a choice that spared her from the scrutiny of the discovery process, including answering questions under oath and producing her communications. This decision was no accident. That's wild to me, that right there. That is an important part that does need to be examined. And the fact that he said, he said he wants to go to trial. So that is definitely going to be the difference between her complaint and his lawsuit. That's apparently no longer true, as just after the publication of this story, Lively's attorney said they had filed a federal complaint against Wayfarer Studios, Baldoni et al. In the Southern District of New York. Unfortunately, Ms. Lively's decision to speak out has resulted in further retaliation and attacks, as alleged in Ms. Lively's federal complaint. Wayfarer and its associates have violated federal and California state law by retaliating against her for reporting sexual harassment and workplace safety concerns. Now the defendants will answer for their conduct in federal court, read a statement from her legal team. That federal suit, which is similar to Lively's CRD letter, refers to Baldoni's unconscionable conduct and accuses Baldoni and his associates of breach of contract. Lively's attorneys added in a statement, "While we will not litigate this matter in the press, we do encourage people to read Ms. Lively's complaint in its entirety. We look forward to addressing each and every one of Wayfarer's allegations in court." And with that, I'm going to end this here and make a part 2. This is a Variety article outlining Justin Baldoni's lawsuit against the New York Times over their Blake Lively story, saying that they cherry-picked communications and posted text messages out of conduct, basically to harm Justin Baldoni's reputation and his PR crisis team's reputation. So this is the part 2. This is coming after Blake Lively and her team filed a lawsuit of her own. Okay, so we just finished up talking about the fact that Blake Lively had filed a lawsuit of her own. And that's where we are right here. We're picking up. The plaintiffs in the Times suit contend that the Times reporters overlooked text messages indicating that Lively's camp may have been waging its own PR war against Baldoni preemptively. The Times article also deliberately ignores that Lively's publicist, Leslie Sloan of Vision PR, once backed by Harvey Weinstein, seeded stories critical of Baldoni, including that he was an actual predator ahead of the film's release. The complaint also states that Nathan's firm was made aware of Sloan planting an unfavorable, false, and defamatory story about Baldoni and his Bahia faith to Page 6, and also planted a false story alleging that there were multiple HR complaints during production. While Nathan and Abel have come under intense scrutiny for their PR practices following the Times story, the lawsuit maintains that they were carrying out standard industry practice, with the two women merely preparing for worst-case scenarios based on Lively and Reynolds' prior behavior, and that no aggressive tactics, e.g., astroturfing, were ever employed. TAG maintained this defensive position throughout its engagement, verifying facts and correcting misinformation without retaliation. By filing a lawsuit, Baldoni, Nathan, and Abel appear ready to see the full context of their text messages and inboxes laid bare in a discovery process. Another allegation made by Lively centered on Heath showing her a video of his naked wife. The Times compounded its journalistic failures by uncritically advancing Lively's unsubstantiated claims of actual harassment against Heath and Baldoni, with the CRD complaint even labeling that footage as pornographic. This claim is patently absurd, the lawsuit says. The video in question was a non-pornographic recording of Heath's wife during a home birth, a deeply personal one with no sexual overtone. To distort this benign event into an act of sexual misconduct is outrageous and emblematic of the lengths to which Lively and her collaborators are willing to go to defame the plaintiffs. The suit adds that the video in question was shown to Lively as part of a creative discussion regarding a birthing scene in It Ends With Us. As for the allegation that Baldoni inappropriately described Lively's character attire as sexy, the suit calls that exaggerated and misleading. Text exchanges between Baldoni and Lively that are included in the complaint show the actress using the word herself when she wrote that her character's clothing should be much sexier. We'll show you both ways, but beanie is much sexier, she wrote, in what appeared to be her advocating for a particular wardrobe option. Lively set the tone, a tone that Baldoni respectfully heeded during the creative process, the suit says. The Baldoni et al. Complaint marks the latest development in a sprawling saga that has already generated an earlier lawsuit filed by Baldoni's former publicist Stephanie Jones against Abel. How Lively's team came to possess the trove of text messages that became the basis for the Times article was initially a mystery. Lively's attorneys confirmed to Variety that they obtained the correspondence via a subpoena to Jones' PR firm, Jonesworks. Still, it is unclear what grounds Jones would have been required to turn over correspondence involving the former client Baldoni or former employees Abel, given that no lawsuit had been filed. It is hardly coincidence that all of the communications on which Lively and the Times now rely were purportedly produced by Jones's company, Jonesworks, LLC, pursuant to subpoena. The propriety of this alleged subpoena is unverified and, at a minimum, highly questionable given Jones's involvement and the means by which Jones first obtained these confidential communication, the complaint notes. Abel, a former employee of Jonesworks, was forced to relinquish her electronic devices when confronted by a Jonesworks security guard, an attorney upon separation from the company. The Times article states that before shooting on It Ends With Us began in 2023, Lively objected to sex scenes Baldoni wanted to add that she considered gratuitous. In response, Baldoni's Wayfarer Studios agreed to provide a full-time intimacy coordinator. But today's lawsuit offers an alternative version of events. In one text message sent by Lively before production included in the suit, she indicates she is in no hurry to meet with the film's intimacy coordinator. I feel good. I can meet with her when we start. Thank you, though. Baldoni's lawsuit also references notes from the intimacy coordinator that included a suggestion that perhaps Ryle, played by Baldoni, chooses not to orgasm after he satisfied Lily, played by Lively. According to the complaint, Lively personalizes this and states, "I'd be mortified if that happened to me," to which Baldoni, following Lively's lead in what seemed like an attempt to connect and develop their characters, says, "I'm not sure about you, but those have been some of my most beautiful moments with my wife and I." The lawsuit also pushes back on a major component of Lively's CRD complaint and the Times' reliance on it for a story. It's a list of 30 items that were allegedly agreed upon during a January meeting that included Baldoni, Heath, Lively, and Reynolds, and a Sony executive. But today's lawsuit claims that no such document was ever presented to Baldoni, the Wayfarer team, or to their knowledge anyone else, whether during that meeting or at any other time, and therefore could not have been agreed to, the suit adds. In reality, many of these items were encountered for the first time in the CRD complaint itself and include references to highly disturbing events that never occurred. The repeated use of the phrase "no more" before each demand falsely suggests that these alleged incidents had previously taken place and needed to cease. This implication is not only misleading, but entirely untrue. As for the meeting at Lively and Reynolds' penthouse apartment in Tribeca, everyone was in shock by Reynolds' outburst, the lawsuit claims. According to the lawsuit, one of the film's producers who was present said in his 40-year career, he had never seen anyone speak to someone like that in a meeting, while the Sony representative mentioned that she would often think of that meeting and her one regret is that she didn't stop Reynolds' berating of Baldoni. Back in August, when coverage of a mysterious feud between Lively and Baldoni began to spiral on social media and in the press, Variety inquired of Sony whether any HR complaints had been filed against Baldoni during production and was told no. Ultimately, the film became a breakout box office hit, earning $351 million worldwide, despite a $25 million budget. The prospect of a sequel became increasingly unlikely given the bad blood between the two main players, but the drama appeared to have died down until late December when the Times story hit. The Times reached out to the plaintiffs for an on-the-record response at 9:46 p.m. on a Friday night, just as the town's agency and law firms had shuttered for the holiday break. The Times said it would require on-the-record responses 14 hours later. The story published roughly 2 hours earlier than that deadline. Okay, so we got a lot going on in this, and everything that Blake Lively put in that complaint, it seems like Justin Baldoni's team, they are checking things off and trying to put that into a different context. I admit I didn't know these people. I didn't know the story. So when I was reading it, I had no preconceived notions. But with the fact that he actually wants to go to trial, the difference in facts that I have come across that I am now putting into a different light is the fact that he actually wants to go to court because he does want to bring out all of these communications. I did not realize when I was first doing these stories that she and her team were not actually trying to be put under oath. And that is the linchpin that is going to make a difference for how this is going to play out. So there is a lot of he said, she said going on. And a lot of the facts don't seem to be in dispute. It seems to be in dispute the interpretation of these facts. So it's going to be interesting. And I do want to know or do want to see if this actually does go to court. Anyways, let me know what you think of all this. Has this changed your mind about what we talked about earlier when it was just Lively's complaint against Baldoni and his production team? This definitely changes my mind a bit on all of this. It definitely brings new information to light, and I am willing to wait it out a little bit longer to see what comes from his lawsuit. Join the conversation. Don't forget to like, comment, and share.